Hello everyone, my name is Daniel Kriegers. I'm an employment lawyer at Chadwick Lawrence Solicitors, and this video will focus on discrimination claims associated with the coronavirus job retention scheme, more commonly known as the furlough scheme, which has been in place for coming up to a year now and which will continue up to the 30th of April 2021. So why is this topic important? Well, the latest lockdown that was announced at the beginning of January has caused many employers to re-furlough employees or to even consider using the scheme for the first time. And the way in which employees are selected or approached to be furloughed is often a source of dispute for some individuals. Interestingly, some people see it as a punishment being placed on furlough, and others actually see it being a punishment being asked to stay in work. Now, the government restrictions currently in place in England and Wales will continue for some time. The current lockdown will eventually move back towards a tier system, we think, as the vaccine rollout continues across the country. So it's very likely that businesses will remain reliant on use of the furlough scheme to assist in facing the pressures and challenges of the pandemic. So whilst the scheme has been a lifeline for many companies, particularly those in the hospitality sector, it would be prudent of employers to carefully consider use of the scheme, as the selection process adopted could be putting the business at risk of future discrimination claims. Now, an employee can bring a claim in the employment tribunal if they believe that they have suffered unlawful discrimination. They would need to show that less favourable treatment had occurred on the grounds of one of the 9 protected characteristics which is set out in the Equality Act. So this would mean, for example, treating an employee less favourably on the grounds of age, disability, pregnancy, or another characteristic. So when deciding to furlough employees, or indeed re-furlough them at this stage, the selection process should ideally be objective, fair and consistent, and if possible, considering all employees on some sort of rota basis so that everyone is treated on an equal footing. The decisions can only be made by employers, so there is no statutory entitlement afforded to employees. We have seen cases in the past where staff members try to insist that they're furloughed, and although they can make requests, there is no right to demand that somebody is furloughed. Now, whilst that does give you as an employer the flexibility to choose which individuals or teams to furlough, if any employees can show that they've been chosen due to a protected characteristic, such as only furloughing part-time staff who are likely to be statistically female employees, or those about to retire or go on maternity leave, and the employee can show that they have suffered some sort of detriment as a result, for example being reduced wages. We are aware furlough pay is capped at 80% or £2,500, or they may have lost benefits, had delayed training, reduced qualifications, overlooked for promotions, for example. Employees may have grounds to bring a discrimination complaint. Now, many employees have had employees either volunteer to be furloughed or have consent or a written agreement from employees to evidence that agreement to be furloughed, and they may be wondering how it is possible for them to bring a claim after giving that express agreement. Now, although they may have volunteered or given consent in good faith at the time, it doesn't mean that they've subsequently waived their rights to make any claims. If an employee found out they were asked to volunteer or were chosen to be furloughed but their colleagues were not, and there was no good reason or fair reason that was applied at the time, the employee would be able to rely on the implied contractual term of trust and confidence, so that duty to maintain trust and confidence in the employment relationship, to pursue a claim potentially against the business. It is likely that employees will speak to each other and find out who was and who wasn't furloughed, the terms associated with that furlough, and from there employees can make observations as to whether the process was fair and objective. As we say, this could give rise to claims from employees who were not chosen for furlough but wanted it for personal reasons, or those who were volunteering by prior consent. Now, the risk of discrimination claims in reality is an extremely grey area. There have not been any claims in the employment tribunal from which any judgment can be interpreted. So in the meantime, we suggest ensuring you can show an objective process is followed when considering which employees to furlough, and if possible, the use of a rota system so that particular roles or employees and not being unfairly chosen for furlough. If you do have any queries about this or need any further advice regarding furlough agreements, potential discrimination, or just general advice, the team is happy to help. Feel free to visit our website, chadwicklawrence.co.uk, for more resources on the pandemic and employment law generally. Or if you need some advice, please email employmenthub@chadlaw.co.uk. Thank you.